Good afternoon again. Thank you again for joining us. I'm Tammy Welty. I'm the Director of Training and Communications here at Bradford Barthel. And we have Greg Fletcher taking the lead today discussing practical tips for drafting stipulations. We also have Scott Clark joining us, and he's going to assist us with all of your wonderful questions. And Scott, do you want to remind everybody about yourself?
Sure. I've been a workers' comp defense attorney for, well, I guess 27 years now, 26, 27. I've been with B&B for 6 years. I enjoy, what do I like? Playing the piano when I can find time to do it. Happy to be here. See everyone again.
Thank you. Okay, Greg, take it away.
All right. Well, my name is Greg Fletcher, and I've been with Bradford Barthel for 25 years now. So, and I've been also in-house counsel before that for 6.5 years with a big insurance company. Practiced down south, practiced in the Central Valley, San Francisco, now Sacramento. So with that, let's get started. Today, we're talking about practical tips for drafting stipulations. Uh-oh. There we go. This is information. It's all, the PowerPoint's available. So anything that you see in the PowerPoint that you want to remember, just get the PowerPoint. You don't have to take notes. This is me and Mr. Clark. Our contact information, if there's something you don't get, you want to follow up, it's a good way to get in touch with us. You can send me an email if you have questions. Now, what is a stipulation? It just means agreement. It's just a legal term for agreement. We have a truncated kind of a settlement called a stipulation and order. It says stipulation and order or award on the form. It's a single form, single page, and it's usually used to resolve limited or single issues. For example, one period of retroactive TD or to settle a lien. And we've all seen those. It's very simple, but it's very handy. You can do all kinds of things with it. I have a trial that was scheduled. It's still scheduled for tomorrow, but we've resolved our issues. So we e-filed a stipulation in order in minutes, and hopefully the judge will see that and we'll be off calendar by today. That's a nice, easy way to get that done. Now, if you're going to settle the case in chief, there are two main options: the compromise and release and stipulations with request for award. And when I say case in chief, I mean all benefits with the exception of medical, because typically you don't settle that in a stipulation. So first, what's the C&R? Traditionally, it's a lump sum settlement, settling multiply and hopefully all issues. It's the only way to settle future medical care. It's funny I say that. You could, I assume, do a stip in order settling medical care, for example, after you did a stipulation. Typically, we will fold that into a compromise and release and include all of the other payments and agreements in the stipulation. Typically, you only settle by C&R if the carrier is not on the risk. That means the carrier either no longer insures the employer or the injured worker no longer works for the employer. And the reason you do that is to avoid duplicate payments. And one can imagine injured worker has a knee injury, settles by stipulations, settles by compromise and release. By somebody makes a mistake, they settle their future medical care, they get $10,000 for their future medical care, but they're still working there. So the next day, they have another injury, same knee, and they need future medical care for that. And you say, well, we already paid you, you need a surgery, but you need a surgery because of both injuries, not just the one. Well, the injured worker says, oh, I'm sorry, I went to the Indian casino last night and all that money's gone. Well, you can't apportion medical care, so now you're paying for a new injury, you're paying for that same medical treatment that you already paid for. So that's the situation that you're trying to avoid. If you settle by compromise and release and you're not off the risk, there may be duplicate payments down the road for injuries and benefits that can't be apportioned. So again, avoid duplicate payment to the injured worker. If the medical award is resolved and the injured worker has a subsequent injury to the same body part, you might be required to pay for that same medical care again because it can't be apportioned. And it seems unfair, and it is, but this is why we avoid it. All right, the advantages of a C&R, and this is what we're all hoping for. We were having some discussion before the seminar about how we don't do as many of these stipulations because we're always hoping to get that compromise and release. because it resolves all issues generally. There is a compromise and release with open medical care, and you can certainly defer one issue or another, but your goal is to get this claim off your books and have no more relationship with this injured worker. And so compromise and release is the best way to do that. It also resolves the right to reopen. Issues such as penalties can be resolved without admission of fault or liability. In fact, under the new rules, if you settle a particular benefit or issue and the penalty, the potential penalty for unreasonable delay of that benefit is not addressed in that settlement document, whether it's a stip and order, whether it's a stipulations, whether it's a C&R, the injured worker's right to that penalty goes away under the new Labor Code section 5814. All right, again, if you're still on the risk, you don't want to settle by compromise and release. You don't want that duplicate payment of future medical care. Sometimes a party is unwilling to settle future medical care. Applicants are concerned about their treatment. They want to be sure that that's covered. They may not have medical care through their work. Defendants, particularly in the past when the MSAs came in outrageously high, defendants would sometimes not want to settle medical care. So it would be our option to settle by stipulation and take our chances with medical care being left open. Now, something's happened at CMS and they're far more reasonable. They seem to be approving a lot of MSAs. So there's less reason to pull back and not settle future medical care. Sometimes, and this is very, very, very rare, sometimes another party, a third party, might object to a settlement for one reason or another. The example that I use here in this slide is the death without dependence unit. If you're settling a death claim and you've cobbled up some dependents because you don't want to pay the state, the death without dependence unit can sometimes come in and object and say, we don't think those are real dependents and we think you owe us. I've seen that happen. It's extremely rare. Occasionally a third party defendant feels that somehow you're stepping on their toes by settling, and they might object, but again, they may not have standing. Death without dependence has standing, legal term meaning that they have a right to sue or a right to get involved in your settlement. It's pretty rare, but it can happen. Now, this is what we're talking about today, the stipulated award. What it really is the parties agree on what the facts are. They stipulate to the facts, and then they're asking the WCAB to issue an award consistent with those agreed upon facts. And this is why we call it stipulations with request for award. Once the award has been issued, it's not wrong to just call it a stipulated award, but we tend to use the name that's on the form. But again, that's what it means, that you are agreeing to the facts, typically the percentage of permanent disability, the periods of TD, the earnings, the indemnity rates, and so forth. So once you agree on all those things, there's no reason to have a trial. You don't have any factual issues, and there's no dispute. Now, when you're first thinking about settlement, when should you be thinking about settlement? And we've all heard this, and this is a good rule of thumb. Do you wait till the injured worker is PNS or at MMI status on every body part? Not necessarily. And do you wait till the claim is denied and you offer nuisance value? The best rule of thumb, and I'm sure most of you are trained this way, consider the possibility of settlement at every stage. We just had an attorney in our office today, a fairly new attorney, excited because she settled for the second time a claim at a deposition. And we all know that that's one of the things that happens. It's one of the reasons that applicants' attorneys, one of the things they like to do sometimes. They can value the case, they get a sense of where this is going. We come in, we offer fairly decent money, and they take it, and then we're done. We throw in an hour or two of attorney time for the depot, and we don't have a QME. We're estimating what we think the value is. And those of us who've done this for a long time, most cases, we have a fairly good sense of where it's going to go. Obviously, that's not always true. But if you don't think about it, you miss opportunities. Hurdles to settlement, sometimes the injured worker, the applicant's attorney, sometimes not even in their own best interest, gets in the way of what you're trying to do and becomes difficult. Sometimes it's the judge or an INA officer who gets involved and backseat drives a little bit. All settlements have to be approved by the WCAB, and that's C&Rs and STIPs. the board rules direct the judge to inquire into the adequacy of settlements, and it's in their policy and procedure manual. It's very different than civil. In a civil case, you can settle for $1, and you don't even have to tell, and most times you don't, you tell the court what your settlement is for. All you do is say, we settled, and you do a motion to dismiss the claim because you've settled. And that's all they need to hear, they dismiss it. Here, the board has been tasked with looking out for the injured worker, and that's where they have to look at all the factors in the case and decide if your settlement is adequate. Now, does that mean that the injured worker gets everything that they possibly could get under the record? No. Settlement is only is adequate if it's within the range of potential outcomes. You kind of like it to be in the middle of the range, but it doesn't necessarily have to be there. The board rule is written in a kind of a funny way, and it says agreements which provide for payment of less than the full amount of compensation due or to become due, and which undertake to release the employer from all future liability will be approved only where it appears that a reasonable doubt exists as to the rights of the parties, or that approval is in the best interest of the parties. The way I look at it is, and again, those of us who've been around can value these things, but even if you have everything, you have a QME, maybe you're arguing about the rating. Applicant's attorney wants to apply kite and add all the impairments. You want to combine them. So you know what the range is. On the one end, if you combine them, you have a lower rating. On the high end, if you add them, you have a higher rating. You compromise and you settle somewhere in the middle. That is going to be deemed adequate, even if the QME said that you should apply kite. If you have a legal argument not to, then you've got a reasonable doubt here under the board rule, and the judge, in theory, should approve that. Now, we all know judges have their own ideas about things, and what they think is adequate and what we think is adequate aren't always the same, and we've all had that experience of having the squeeze put on us to come up with more money to satisfy the judge. Part of our job is to kind of figure out who we're dealing with on the other side and what the judges like and don't like to see, so that we can tailor our settlements to be approved without a whole lot of questions. All right, the tools that the WCAB uses to assess adequacy are the DEU. Often, if it's complicated, a judge may just ask you, go get a DEU rating. They love the DEU. We have some problems because the DEU can no longer editorialize about what they're doing. I believe it's the Blackledge case that said they just provide a rating with no comment. And they kind of love that because that puts them off the hook. They do a little less work. We then have to make our rating arguments kind of on the side. We don't get the DEU coming in and saying, we have questions about this, or there's an issue here. If you recall, those of us have been around a long time, before Blackledge, there would be comments in the DEU ratings, and sometimes they were quite helpful. Now it's a rating on its face, and we are left to argue that it's correct or incorrect, depending on what our rating issues are. The INA officer, if you have an unrepresented injured worker, the INA officer can be your friend. Other times they'll call you up and they'll ask you what's going on, and they'll have an injured worker in there complaining about you. So, but the point is that the judge often relies on the INA officer quite a bit. And depending on the board you're at, in some boards in the old days, if you had a pro per, they would want you to talk to the INA officer before you even brought the settlement to them. They would want a note from the INA officer saying, I reviewed this, I recommend that it be approved, something like that. I haven't seen that in a long time, so I'm really not sure up here if they're relying on them as much. But I have used INA to help me accomplish settlements, so they're not always adversarial with us. Now, what do we have to establish adequacy of the settlement? See, our job, we've got to deal with the injured worker or their attorney. Now we have to sell it to the board. We can draft it in such a way that it's clear and that the board knows what we're doing. We can provide all the supporting documents so that they understand that what we're doing is, it's not just our say-so, that we have notices, we have the QME reports, we have benefit printouts and so forth. And of course, explain. What you don't want is the judge to not understand what you're trying to do. The clearer it is, the more likely it'll be approved. So once you submit your settlement, the judge can approve it, suspend it, and make inquiries regarding the basis of the settlement or documents that might be missing. They could set a hearing on adequacy, or they can just disapprove it. They cannot make unilateral changes to your settlement documents. They can't just redraft it for you. I've been hearing anecdotally that some judges in other parts of the state lean on people to change their documents and threaten to go to trial if they say no. Now that sounds a little bit like it might be getting close to or crossing the line. I don't think that's technically improper because the judge has the power to set something for trial. And they can certainly tell you what they'd like to see in your settlement documents. What they can't do is change it and then issue an order approving that change. They can disapprove it if they don't like it, but they can't change it for you.
Hey, Greg, can I just pop in real quick?
Sure. Yeah.
Yeah, you mentioned different parts of the state, and we had a quick little talk beforehand. But particularly those of you who are doing workers' comp down in Southern California, and in particular the Long Beach board, I'll just watch my words. It's not a typical WCAB. I wasn't sure how I wanted to phrase that, but you've got some judges there who really like to push the envelope in terms of pressuring people to phrase their documents exactly how they want them. So we've got to play, you got to ride the line there pretty closely, make everyone happy, but at the same time, represent your clients and get the job done. But we do have that issue at Long Beach in particular, and it's a big issue. It's a big issue. Sorry to interrupt.
No, that's fine. This is important because our clients and our attorneys are all over the state. So if we say something that's venue specific, then we might send them off to have problems. But
Right.
This is the advantage of either knowing somebody who's local or being local. And certainly our attorneys are pretty accessible. And if you have questions about the judge, about a venue, or if you maybe want to send it to somebody who's in that venue to walk through, you get that advantage of understanding the local culture. Somebody who knows. One quick war story. My first appearance in San Jose, a judge who's retired, Judge Levin, so I can say his name, was notoriously difficult. I had an applicant's attorney who was pretty friendly. I got to know him after that, but he walked me through what the judge would approve and not approve, and I got authority, and we went in. And to be fair to us, the judge that day had a cold, so he wasn't really in himself, but he just looked at it, signed it, and everyone on the audience there gasped. They couldn't believe it. But that was because I had help with my so-called adversary, but we had agreed on a settlement. So we were, at that point, working together to get it approved. So that local knowledge is invaluable. Not only the judges, but the doctors and, all kinds of aspects of the local board and the local culture can be used in a way that can facilitate you getting your settlement approved. All right.
Sorry, one more quick thing while I'm on with you. We do have a question from anonymous attendee. Has anyone seen an increase of INA officers encouraging the employee to proceed with a PQME panel after submitting STIPs based on the PTP? I have not noticed that, but have you, Greg, up there?
I have not, but it doesn't surprise me because that's the kind of backseat driving that INA sometimes does. They frame it in the sense of you have a right to a doctor. That report's kind of low. Why not take a second bite? I can easily see that. Yeah. So that's something to be aware of when you have a pro per. That QME waiver is a bit dicey. Some judges look at them sideways.
Yeah, and one more. Oh, I'm sorry. Go ahead.
I was going to say, even the judges, I've seen them pressure injured workers to go to a QME rather than take a settlement.
Yeah, and there's one question popped up from Stephanie. Have you noticed WCABs disapproving C&Rs and adding notes more frequently in the last 3 years? In Long Beach in particular, they like to not necessarily disapprove, but issue order suspending action on C&Rs, and they'll force you to come back and prove, why you want the C&R approved. That happens a lot, and yes, more often than the last few years. But how about you up there?
I would say it depends on the judge, but there's certain judges in what was Stockton, which is now Lodi, that do a lot of order suspending and like to pull people in and grill them and so forth.
Okay, I'll leave you alone now. Proceed.
All right, very good, thanks. All right, so what are we doing when we STIP? We're admitting injury. Medical care is typically left open. We specify the periods and the rates of payments. And this is very important. If you settle by stipulation, the injured worker has the right to come back and file a petition within 5 years of the date of injury to reopen the claim for new and further disability. So this is one of the real downsides to a stipulation, is it doesn't necessarily set your PD in stone, because if you're within 5 years, they can come back and reopen it. And I've had people reopen settlements 6 months later after they settle. I mean, just you wonder what's changed. We also had an attorney down in back when it was Stockton, who back when we had dueling QMEs would get caught short and would not have gotten his QME. So we'd enter into a stipulation to our QME and then file a petition to reopen it the next day. So that was pretty disingenuous in my opinion. All right, stipulations need to be very carefully drafted. Unlike a C&R, in many cases, ongoing administration of the claim may be based on the terms of the stipulation. For example, you stipulate, but all the PD hasn't been paid, so you have to continue to pay PD. You're doing that pursuant to the stipulation. You might have a life pension after the PD's paid out. That's going to be paid pursuant to the stipulation. That might be subject to the COLA, which has to then be increased according to the COLA. If there's a commutation, there are different ways of addressing that commutation. That's all spelled out in your stipulation, and you need to pay pursuant to those agreements. And then finally, the ongoing administration of the medical award. Even when all the indemnity is paid out and you have this stipulation in your file, you're not done. They have a right to medical care, and that's in the medical award. And if it has to be enforced, someone's going to take a look at that stipulation and look at what did you agree to. So, we hope that a C&R is one and done. You just enter into it, get it approved, and close your file. But with a stipulation, you might have to live with it for a while. And the parties are bound by their stipulations. That is the famous Weatherall case. If you stipulate to injury, you can't take it back. And in fact, even when there's a petition to reopen, and this is an unpublished case, but I think it's probably good law, you can't withdraw a stipulation to an injured body part even after the injured worker files a petition to reopen. We tend to view petitions to reopen as blowing up the earlier stips, but that's not entirely true. However, if you stipulate to some but not all body parts, then the WCAB may have continuing jurisdiction over adjudicating the injury to those body parts. So you do want to be comprehensive and address all injured body parts and all impairments in your stipulation. All right, now we're getting into the form. It's an OCR form. It is similar in some ways to the C&R form. There are some odd differences. I think they were drafted by different people. It's a little hard to fathom how they evolved separately. Page 1 requests venue information. That's important. If you, for example, have a pro per and there's never been an application filed, your stipulation is your application, and that will establish venue. And you obviously would like to be at the board that's the friendliest, but there are rules regarding venue, so you have to file where it's appropriate, where the injury occurred, where the employer is, where the injured worker lives. All right, you have the party information. Essentially the same as in a compromise and release. Case information is also similar. Pay very special attention to description of the injured body parts. We'll get into that a little bit later. The form provides for multiple employers and carriers. For example, if you have a long CT, you might have multiple parties involved. Accurately identify the parties, especially self-insured employers, carriers, and TPAs. A lot of people get confused as to whether they have insurance, whether the TPA is the carrier, whether they have self-insurance. There was a case, the Cold Iron case, back in 2002, that there's a site here, but that case has also been codified as Regulation 10390. And it basically says, if you don't properly identify your party, you can be sanctioned. And when I say your party, your principal, who are you working for? Yeah, particularly attorneys out there. Make sure you understand who you work for, if they're a TPA, if they're a carrier, if they're self-insured. We had some judges, and I think this is kind of bad faith, but they had a list of the self-insured plans. And if somebody said their client was self-insured, they would look at that list kind of on the side and not share it, just kind of look at it and then threaten to sanction you because you're not on the list. Well, they could be friendly and say, you're not on the list. Could you check? It doesn't have to be so heavy-handed. And by the way, in Cold Iron, the party who got sanctioned turned out to be SIGA. Now, those of you who have dealt with SIGA understand that that's a completely different animal than your typical carrier, employer, TPA, or self-insured employer. SIGA is a creation of statute. They swoop in and adjust claims after a carrier has gone bankrupt, but they only pay in what's called covered claims. So if there's any other insurance, the burden then shifts to the other insurance. Why is that important? Well, if you don't tell people you're SIGA until late in the case, suddenly their liability is shifting around and they've really been prejudiced. So there was good reason in Cold Iron to sanction that defendant. I'm not sure that it matters as much with some of these other issues, with one exception, and that is the board really does need to know who's on the hook for payment when you agree to something. And for example, if you list the TPA, they're really not the one who pays. And there may be an issue later when this agreement is being enforced as to whether you can enforce it against the actual principal. So there is good reason to understand who the parties are and be accurate in describing them. Now, here's the form. You get the case number up here, social security numbers. These days, they're a lot looser about social security. They're privacy issues. I've seen a number of settlements that don't have the social security number on there. That's going to be board specific, I think, and maybe even by the practitioners. Here's the venue. Typically, it's the residence of the employee or where the injury occurred. If you've got a pro per, they don't have an applicant's attorney, so you wouldn't use their place of business. But often that's the basis for the venue. I'll go back sometimes and look at the application, and wherever the applicant's attorney is checked, I will use the same one. Use the 3-letter abbreviation for the board you're at for the venue, and then often I will leave the address blank for the applicant, because if their address has changed and you use the old one on your file and you send payment to that address, they may not get the payment. And if you have them fill it out, then no one can say you sent it to the wrong address when you send it to the address they put on the C&R. I think if you send it to that address and that turns out to be some sort of error, I think it's their error, not yours, so you avoid a penalty there. So you got employer number 1 and the insurance carrier and the claims administrator. Again, if there's a carrier and a TPA, use both sections. If the carrier is doing their own adjusting, all you need is the carrier. And then here's employer 2, carrier 2, and so forth. And that goes all the way through employer number 4. And then down here at the bottom of page 4, we're getting into the actual claim information and starting with the injured workers information and their birth date. And employed at is not the name of the employer, it's the place, it's the city, and California, because again, the board is trying to establish jurisdiction. So they want to know where the injury occurred. If it didn't occur in California, there may be some jurisdiction issues. There may not be. List the occupation. And again, you're stipulating to that. So again, you want to be careful. If it's in dispute, if there's some issues about the occupation and the group number, work that out with the injured worker. You may be bound by the stipulation. All right, you've got spaces for 4 cases, and kind of interesting because these days, typically you're going to be doing 1 stipulation per case. But if you have a case of multiple injuries and, for example, your evaluator can't apportion between them, Benson apportionment allows for the evaluator to cop out and say the injuries are inextricably intertwined. In that case, they're going to be permanent stationary together. You're going to have 1 rating, and so you could have 2 injuries and 1 rating, and that would be appropriate in your stipulation. Now, the body parts listed up here should be listed as they are in the application. In other words, the code and the body part. If there's something different, something specific, you have some space down here to clarify. For example, EAMS doesn't specify right or left, shoulder, knee, upper extremity, hand. Here's where you can put right knee and make sure that you're limiting it. Because remember, you're bound to what you stip to. If you say knees and you don't specify right or left, and it turns out it was just the left knee, you bought the right knee too, because that's what your stipulation says. Now, if you've got a specific injury, you check the box and you use the start date as the date of the specific injury. If it's cumulative trauma, you check that box, you have a start date and an end date. And typically that's the start and end date that the injured worker has alleged. If there's some reason why the date of injury has been adjudicated and it turns out to be different than what's alleged, you may want to explain that in the comment section. But I typically go to the application. I'm settling what the injury they alleged typically. All right, remember, Stipulated awards, medical care remains open for all injured body parts. Stipulations are going to be construed against the defense. Typically, it's a legal principle that documents are construed against the drafter. We typically are drafting these things, but there's another reason, and that's just the paternalistic nature of the board in looking out for injured workers. They're going to construe these things in the way that harms the injured worker the least or benefits them the most. So why do we want to be narrow? Because if you injured your toe and you write lower extremity, you're going to provide treatment for that entire lower extremity, not just the toe. If you injured the toe and you say toe, in most cases, they're going to be limited to the toe. Foot instead of lower extremity, low back instead of back or spine. Now, there are going to be some exceptions, and we'll get into that. But here's a real example that should scare all of us out there. Someone stipulated to just internal injuries. That was construed to include fibromyalgia. Now, that's a stretch. First of all, I don't think fibromyalgia is an internal injury. I think it's more of a neurological condition. But you know what? It was coined by rheumatologists, and they don't really know what it is. So, again, be careful. You don't necessarily want to open Pandora's box. And the language at the bottom of page 5, that was the box that we were looking at down here. That's going to control as opposed to just the codes. And so that's good news, because that means you can tailor this to be specific. You're not stuck with the generic descriptions in the EAMS list. Another example, injury to the heart was considered broad enough to include aortic valve disease that the AME in that case happened to have found non-industrial. So, if you've got something like this where an AME has found some of the condition relating to the body part that was injured to be non-industrial, you may want to spell that out somewhere in your settlement documents. We're not buying this non-industrial stuff. I'm not sure exactly how you do that. That would be very case specific, and judges might start looking sideways at it. But it seems to me if the AME is founded, there's a way to draft it that wouldn't cause this problem. First of all, you don't want to stipulate to injury to the heart. You want to stipulate to whatever that, is it hypertension? Is it, what exactly about the heart are we stipulating to try and keep it out of those other categories? Now, here's the exception. If the injury causes a compensable consequence injury to another body part, then medical treatment for that compensable consequence injury is going to be allowed. This used to be a little bit controversial, but there's a fairly recent case that reaffirms this principle. It's the most recent case in the seminar, Shaw versus Automobile Club of Southern California, 2023 case. But so, if you stipulate the left knee and through overuse, the right knee starts hurting, you may buy the right knee because it's a compensable consequence. Now, that should be documented, and the reports that find it should be substantial evidence. Just because they say so doesn't make it so. This is something you would want to work up. You'd want to have medical support that there really was a compensable consequence, not just an allegation. All right, here's moving on in the form. The injury causing temporary disability, you actually have 2 periods in the STIP form, whereas you only have 1 in the C&R. That makes it a little more flexible. We all have cases where TD starts and stops, and in the C&R seminar, there's a whole section on how to handle multiple periods. Suffice it to say that you just want to be accurate. You could provide a start and a stop date and say it was in broken periods. You can provide in the comment section every additional period. You just want to make sure that you get credit for what you've paid, and nobody can come back later and say, oh, you didn't pay all the TD in this case. You also have a section where this is where you put the percentage of permanent disability and the rate. Just like TD, you have the indemnity rate and then the period. Here you have the period and you also have the rate as well. And then for PD, you have a total. I'm sorry, for TD, you have a total, and you have, I believe, a total here too. Yes. Now this form is the pre-1113 form. I thought I'd throw it in. Back in the day, if there weren't offers of modified or regular work, PD would be increased by 15%. We don't see this hardly at all because that those cases would have to be quite old. But just be aware there's a different form. You can check a box not applicable, but you have to increase or decrease that rate depending on when the offer went out. The rest of the form is essentially similar. And this is the new form, relatively new. Again, you've got the 2 periods of TD, permanent disability that you're stipping to, and typically the TD is all paid. This permanent disability section, you have a beginning date. You notice you don't have an end date because you may be beginning, tomorrow or yesterday. So that's going to go out until it's all paid out. You check a box if you have a life pension. You indicate the amount of the life pension. It's a little outside of this seminar, but if you are commuting the life pension or the PD for purposes of paying an attorney fee, that means you get a present value figure and you take an attorney fee off of that. And then the remaining benefit is paid at a lower rate, or you skip a certain number of weeks if it's PD that's being commuted. That's rather complicated. We have someone in our firm who does ratings, but also does commutations, Tim Musak. I would strongly urge you to consult with him if you have a commutation issue. I'm going to be doing that myself in a 100% case shortly. But the point is that just these days with Baker and with the COLA, just saying the amount of the life pension may not be enough if there was a commutation and an attorney fee. And you check a box indicating whether or not you had a DEU rating. You check a box indicating whether there is or is not need for medical treatment.
Hey, Greg,
Go ahead.
I'm sorry, can I pop in just for a quick second?
Sure.
I didn't want to get too far away from it. So this is just a little idiosyncrasy I have with STIPs. And as far as I know, I'm the only person on the planet that does this. So if everyone thinks I'm just a neurotic freak, that's fine. I accept your judgment. But under paragraph 3, where it says less credit under the PD section, where it says less credit for such payments previously made. The question always comes to mind, what does that mean, such payments? To my mind, that means the payments referenced just before that phrase, which is PD paid during the time frame that we're setting forth in the settlement document. So 90+% of the time, PD payments are made only from the MMI date forward, obviously. But every now and then, you'll have some random case where an applicant wants a PDA, maybe he's not getting TD because of a modified duty issue or something. But then if your defense attorney puts in the settlement documents, PD is paid from the MMI date forward, technically you may be only taking credit for that period of time. So what I'll do, and I guess you don't need to do this, but I cross off the word such and I put PD in its place. So that it says less credit for PD payments previously made, so you're not limited to that time frame. So you're covered in case you make a glitch or you don't pay attention and you just use the MMI date as the beginning date, and then it turns out there was a PDA made before that. So for whatever that's worth, just maybe something to look out for.
I've never seen that become an issue, but I certainly don't think it's wrong. And the other thing you could do is in the comment section, if you're at all concerned, just write, parties contemplate credit for all permanent disability advances previously made, something along those lines. You definitely want to be clear. If you don't spell it out, it's going to be construed against you. So here's a place, medical legal expenses, that's your QME, your AME typically. I usually just write all paid or will be paid pursuant to the medical legal fee schedule. And then I hope that my clients are doing that. Here's where the applicant's attorney can request a fee. And if they're going to be commuted, you check the box and typically you would write from the far end of the award if that's how you're doing it. Again, it's a bit of a technical question. Liens against compensation, typically people put all liens in there. It's a funny thing. There are only certain liens that are actually against compensation, and that would be things like liens for living expenses or child support that actually come out of the settlement. But this is customarily taken to mean all liens. So this is where you would recite the liens that you take care of, unless you're a Southern California practitioner, in which case you have a lien addendum. The liens won't fit in this little box in many of those cases. So and they require them. It was optional when I practiced down there, but we had them because we had lien problems even then. And they have to be very vigilant with liens because they pile up. They've had periods when the board was tens of thousands of cases behind in adjudicating because of liens. And they actually had to set up lien units and really crank those things through. So we can complain about the diligence of the boards down there, when it comes to the liens, but they have a really legitimate reason to try and make sure all those liens are taken care of and adjudicated. All right, this is what we talked about briefly. There are two different forms for injuries before and after 1/113. Because there's a 15% increase or decrease in PD. The thing everybody misses, you have to have 50 employees for it to apply. You check for the offer of modified work, increase the remaining PD by 15%. This goes back to a little bit what we were talking about. If you'd paid PD earlier, then that's not increased. It's already been paid. Only the remaining PD to be paid would be increased. Again, you're probably not going to see this unless you have some very, very old cases. The money charts assume that there were no PDAs prior to the P&S date. Back in the day, the money charts included the 15% increase and decrease, and that kind of led people astray because they would assess it against the full PD amount, even if some PD had been paid before. All right, note that the STIP form provides for 2 periods of TD, the provision for the life pension. Is there need for medical care? You've got to check that box. Now, you'll have QMEs that say no medical care. Sometimes treaters will discharge people. If you're going to check the box that says there is no need for medical care, make sure there really isn't, because this is a red flag for judges, and this is one of the things that will flag your settlement for a suspension or possibly even disapproval. If there's any hint, for example, I had a QME say no need for medical care, and my client wanted to push it, so I tried to stip the case out with no need for medical care. The judge looked at the surgeon's report. The surgeon said, if you're symptomatic in the future, come back and see me. That was enough for the judge to say, aha, they've opened the door for medical care. I'm not going to approve this. So I called the client. The client said fine, and we withdrew that. We checked the box that there is need. Those of us who've been around as long as me remember there used to be a box that said there may be need. That was sort of problematic because what does that mean? But we love checking that one. That's the one I always checked. All right. Yeah, again, if the treatment records contain any hint of a possibility of future treatment, or even if the QME hints at it, or if the language is ambiguous, it's very difficult to get a judge to sign off on a settlement with no medical care, and you're not paying for that. In a C&R, you're paying for the medical care that's estimated. The STIP, it's either left open or it doesn't exist. All right, can you limit future medical care to treatment recommended by the AME or the QME? Probably not in Northern California, maybe in Southern California, but be careful what you wish for, because here's the case from 2014 where they stipulated to the treatment disputes to be resolved by the AME. That was viewed as a waiver of the IMR process. Now, we don't want to do that. I like UR and IMR better than I like my AME. So, yeah, it's just something that we constantly are trying to sort of push back against this open-ended nature of the medical award and trying to limit it, but it doesn't always work, and the judges hate it. So it's better to leave it open and fight your fights at the UR level and at the expedited hearing level than try and craft some kind of fancy language in a stipulation that may or may not be enforceable. All right, the form distinguishes between medical, legal, and liens against compensation. This is the language I put in: all paid or will be paid per the medical legal fee schedule. It's hard to argue with that. You want to follow through and make sure it's done so you don't have any problems in the future. Most of our QMEs and AMEs, in my experience, are paid by my clients, and I don't really see too many disputes about that. Liens against compensation. We can use the pay adjuster litigate language like you use in a C&R. True liens against compensation are living expenses and child support, possibly EDD. Sometimes we want applicant to pay EDD back if they double dipped. It's a difficult thing to get, but we sometimes fight for it. Now, here's where we get to other stipulations. This is your chance to explain anything that needs to be explained about your settlement. I typically put the basis for the settlement. You're stipulating to 20% PD. Where did that come from? Put your rating string in there. Then the judge can say, oh, I know exactly how they did this. And then applicant signs here and dates it. And then we have information about the attorneys, if there are any attorneys, and there's more than one. Interpreter has a space for their license number and to sign off if they help the injured worker. So other stipulations used similarly to the comment section of the C&R. That's your opportunity to explain the basis for the settlement, and especially all the issues that have been compromised. What was the range of outcomes? How is your compromise adequate? Your compromise of the issue, not necessarily compromise and release, but your stipulation may be to a compromise, for example, of earnings. You might have the injured worker saying, I had outside earnings, and you're saying, well, you can't document them, that's just your word. And then maybe you agree that you'll increase your wage statement by some amount that's in between the two numbers just to get it done. Explain that. Provide the rating string? Absolutely. It shows the basis of the settlement. Labor Code Section 4664 provides a conclusive presumption of PD in your stipulation. You don't need a rating string for that. But there is case law that says that permanent disability, in order to get that credit, has to overlap with the impairments in the current claim. So your rating string shows the impairments that you're rating. And so that can be used to establish that overlap so that you definitely keep that presumption that permanent disability is there. That allows you to just subtract it right out of the current impairment. It's very helpful. It's our best apportionment in the statutes that we have. So other things that you could be explaining, I just mentioned this, a compromise regarding earnings. There might be disputed temporary disability periods. You can say this settlement includes a payment of X amount. It could be a lump sum to resolve the disputed period of TD from X to Y. And that then resolves that. You don't have to do a separate stipulation in order. That can be written right into your stipulations with request for award, and that resolves that issue. Disputed body parts. Sometimes, you get a settlement, or I'm sorry, an application that alleges, skin and contents, but it's really a back injury. And the QME finds a back injury, and you settle based on the rating of the back injury. But the toe, the knee, the skin, the psyche, the nervous system, all of those things, you don't want to leave them dangling. Remember that earlier slide, which indicated if you don't settle those body parts, the WCAB may have jurisdiction over them. So in the comment section, write this settlement, for consideration in this settlement, these allegations of injury to these body parts are hereby dismissed. So then it's done. Then you've settled everything that's been alleged. Use it to explain the basis of settlement. Medical reports. Typically, if I provide a rating, I also provide that dollar amount. Identify the report you're rating, obviously, and who the doctor is. The compromise and release form has boilerplate that includes interest if payment is made within 30 days. That's something we always used to write into our settlements. It's now right there in the C&R form. For whatever reason, it's not in the stipulation form. So in order to avoid claims of penalties from some of these penalty kings who look for every day and every cent, just put interest is waived if payment is made within 30 days of the service of the award pursuant to these stipulations. That way, you've got 30 days to pay, and you don't have to worry about interest. Get your payment out in time. Your payment is done. It's a little different with stipulations than a C&R, because C&R is typically an applicant's attorney check and a check to the applicant. Stipulations, you might already be paying the PD, and you just continue to pay pursuant to the stipulation. So there isn't really any new payment. On the other hand, sometimes the stipulations are all due and payable. Everything that's happened was some time ago, and you're finally getting to where you had a report. The report retroactively finds the person MMI. So everything was due back then. Then you definitely want to pay on time, because you'll have a penalty on that entire payment if it's late. All right, other stipulations use it. Oh, signatures. No need for the applicant to sign in front of witnesses or a notary. That's another odd change between the C&R and the STIP. They just sign and they're fine. Whereas with the compromise and release, they've either got to find 2 witnesses or go get a notary. Now, Labor Code Section 5814C. I did mention this earlier. This is the statute that says if you resolve an issue and there have been claims for penalty, or there might be claims for penalty, and they're not addressed in the settlement, then they're conclusively presumed resolved by the operation of Labor Code Section 5814C. So If somebody has claimed a penalty, or if somebody's claiming your TD is late, and you recite the TD that you paid in your stipulations with request for reward, and there's no mention of penalties in there, those penalties are gone. And I've had judges enforce this. If the claim for penalty for unreasonable delay in any benefits being settled, the penalty issue must be expressly deferred, or it will be deemed resolved. Now, that's something the applicant's attorneys need to remember. We're certainly not going to help them out. So all other issues deferred might not be good enough to preserve that claim of penalty. I wouldn't put that on there to fool the applicant's attorney. If they raise it, you want to address it. But if they don't think about it and they don't raise it, and you settle those issues, you settle those benefits, the penalties are gone. All right, what do you submit with stipulations? Obviously, your settlement documents, your legal reports, your treatment reports if you need them, earnings information, printout of benefits, benefit notices, anything that supports a finding of adequacy. If there's anything odd about your settlement, consider a cover letter. This temporary disability was denied because this person quit their job and they were terminated for cause, or whatever the reason is, that you want to explain what you're doing that might be a little funny. The bottom line principle is explain what you're doing, and if the judge understands it, they're more likely to find it adequate. If you get an order suspending action on your STIPs, don't panic. It's not disapproving the settlement. Typically, it's just asking some questions. If the judge has questions, write to the judge and answer them. Sometimes that's good enough and they just approve it at that point. Provide whatever documents they requested. Again, don't panic. It hasn't been disapproved yet. Even if it's been disapproved, you can try and figure out what does the judge want and try and regroup and submit another settlement. But anyway, that's it. And we've got, I think, 1 minute left. Here is my contact information once more. And if we have another question, we've got a minute to answer it. Otherwise, thanks for listening.
There's one quick one that came up earlier. I was going to ask you, but about wet signatures. Do you have any trends you see up there about wet signatures on settlement documents?
That's a really interesting and good question. The board rules, I think, don't require them anymore. But we have had a judge in Lodi, I believe, look sideways at a settlement because there weren't wet initials on the issues on the C&R, the issue section where you initial them. I don't know what the reasoning for that is. So I try to use a wet signature when I can. I mean, it's a copy of a wet signature, but I don't use the computer. I don't type my name. I don't type the initials on there anymore after hearing that story. But I don't think I think the board rules don't require the wet signature at this point.
Right. Same down here. I could just reiterate what you said. The occasional judge wants the actual wet initials on page 6 or whatever it is, but generally they're not required.
And if you know that and it's not inconvenient, why not do it? Right?
Right.
Okay, well, thank you, Greg, and thank you so much, Scott, as well for helping today. That was a lot of really fantastic information. Our June webinar is going to be on June 25th with Tim Musak, who I know Greg mentioned, and I did provide his contact information for anybody who wanted that. Tim's going to talk about PD rating and the schedule on June 25th. But if you go to our training page at bradfordbarthel.com, you can register for our June and July webinars. I will be sending certificates this afternoon, and I will include a link to the PowerPoint presentation for those of you who asked. And I think that's all from us, you guys. Have a great rest of your week. Thank you so much for joining us today. Take care.
Thanks again.
Bye-bye.